If you have a green card, if you're waiting for one, or if you've already submitted your application and you're just waiting for a decision, this video is for you. Because right now, in late April 2026, USCIS has made some of the most significant changes we've seen in years. And these changes are not rumors. They are not speculation. They are confirmed updates from official government sources, and they are affecting real people right now. We're covering 4 major things today. First, a critical change in how employment-based green card applications must be filed starting in May. Second, an ongoing re-examination of previously approved immigration cases and what that actually means for you. Third, the return of mandatory interviews and what to expect if you get called in. And fourth, processing delays, backlogs, and the very practical steps you should be taking right now to protect your case. Stay with me through this entire video, because missing even one piece of this could cost you months, or in some cases, your entire window. Let's start with the biggest change of the month. If you are in any employment-based green card category, EB1, EB2, or EB3, you need to pay very close attention to this. For the past 18 months, USCIS had been allowing employment-based adjustment of status applicants to use what's called the Dates for Filing chart. This is the more generous of the 2 charts published in the monthly visa bulletin. Using this chart, many applicants could file their I-485 adjustment of status application early, even before their green card was technically ready to be approved. It allowed people to lock in their place in line, get their work permit, get their travel document, and essentially get a head start while they waited. That option has now been removed for employment-based categories. USCIS confirmed just days before this video that starting with the May 2026 visa bulletin, employment-based applicants must use the final action dates chart, not the dates for filing chart, the final action dates chart only. Now, why does this matter so much? The final action dates chart is the stricter chart. It tells you when USCIS can actually approve your green card, not just when they'll accept your paperwork. For many applicants, especially those from high-demand countries, that chart is significantly further behind. And if your priority date is not current under that chart, you cannot file your I-485 in May. This is a direct reversal from what was allowed in April, and it caught many employers and applicants off guard. Here's the practical impact. If your attorney or your employer's HR team had been building an adjustment of status package based on April's dates for filing chart, that package may now be ineligible. Your case may need to wait. Or you may need to switch strategies entirely and pursue consular processing abroad instead of adjusting status inside the United States. Immigration attorneys are recommending 3 things right now. 1. Go to the USCIS website today and find the May 2026 final action dates chart. Compare your priority date to that chart for your specific category. If you're not current under that chart, do not file your I-485 yet. 2. If your date is current, talk to your attorney immediately, because there is a window here, and it may not stay open long. We'll explain why in a moment. 3. Preserve all your documents, especially your medical exam from Form I-693. Medical exams have limited validity, and you don't want them expiring while you're waiting. Now let's talk about what the May Visa Bulletin actually shows for each category. For most countries other than India and China, the EB1 and EB2 categories are marked as current on the final action dates chart. That word, current, means there is no priority date cutoff. Your case is eligible for full adjudication right now, from filing all the way through final approval. For people from countries like Mexico, the Philippines, Brazil, Colombia, most of Europe, Africa, and Asia, this is genuinely significant. If you have an approved I-140 petition in the EB1 or EB2 category, your path to filing is open right now. But here's the warning. that the visa bulletin itself includes, and this is directly from the Department of State. Dates have been advanced to use the visa numbers available in fiscal year 2026, and retrogression may be necessary later in the fiscal year to keep issuances within annual limits. Retrogression means dates go backward. A category that shows current today could have a cutoff date again in 2 or 3 months. And when that happens, people who haven't filed yet will lose their eligibility window entirely, while people who already filed are protected. The last time EB2 was this broadly current for most of the world was in fall of 2022. That window closed within a few months. Immigration attorneys are saying the same thing right now. If you are eligible, file before the window closes. For India specifically, the situation is very different, and it's important we cover this honestly. India's EB1 cutoff is around April 2023. EB2 India is cut off at July 2014. EB3 India sits at November 2013. These are not months of waiting. These are years and in some cases decades. There was no meaningful forward movement for India's employment-based categories in May. For China-born applicants, the picture is similarly constrained, with cutoff dates well behind the current year. The EB3 Other Workers category did see modest movement, and the EB5 Investor Visa Program's unreserved category also advanced, but the bulletin includes a specific warning about EB5. Demand in this category is rising fast, particularly from applicants from certain countries, and officials have warned that retrogression or temporary unavailability could happen before September 30th, when fiscal year 2026 ends. For family-based applicants, the situation is more favorable. USCIS has confirmed that family-sponsored categories will continue to use the dates for filing chart for May. So if you're in a family-based category, your ability to file early is still intact. Family categories did show movement in May. F1, unmarried sons and daughters of U.S. citizens, advanced nearly 6 months across most countries. F2A, spouses and children of permanent residents, remained current. F2B and F3 also moved forward in several subcategories. Now let's talk about something that's generating significant attention in the immigration community right now, and we want to cover it carefully and accurately. USCIS has announced increased scrutiny of previously granted immigration benefits, and it has stated publicly that certain past cases may be reviewed. USCIS Director Joseph Edlow, who was confirmed by the U.S. Senate in July 2025 and is the current confirmed head of the agency, made public statements indicating that USCIS is expanding its fraud detection efforts, including re-examining certain previously approved cases where there may be indicators of fraud or misrepresentation. The agency launched an initiative called Operation Paris, led by the USCIS Vetting Center. This program is designed to review past approvals for eligibility issues and potential fraud. USCIS has also announced it is expanding tip lines, channels through which the public can report suspected immigration fraud, and that it is working in coordination with ICE and Customs and Border Protection on enforcement actions. USCIS has also confirmed it is conducting a country-by-country risk assessment in coordination with the Department of State. This analysis is guiding future screening standards and adjudication practices. Additionally, a policy memorandum issued earlier this year placed processing holds on certain benefit requests, including some I-129, I-140, I-539, I-765, and I-485 applications for applicants with ties to countries identified in presidential proclamations restricting entry. Even approvable cases can be delayed at the final decision stage under this framework. Now, here is the part that matters most for the average, law-abiding green card holder watching this video. Under established U.S. immigration law, USCIS does have legal authority to revisit a prior approval if there is evidence of fraud or misrepresentation. But this is a legal process, not an administrative overnight reversal. USCIS must issue a notice of intent to rescind. The applicant has the right to respond. If the person challenges it, the matter goes before an immigration judge, and the government must meet its legal burden of proof. If you obtained your green card through legitimate documentation, a genuine qualifying relationship, or real employment, you have legal protections under the existing system. The process cannot simply erase your status without due process. However, and immigration attorneys across the country are raising this, if there were any inaccuracies in your original application, any documents that were exaggerated or not fully accurate, or any circumstances in your case that did not fully meet eligibility requirements at the time, the increased scrutiny environment makes it important to review your case with an immigration attorney proactively rather than waiting for something to arrive in the mail. There's also a specific clarification that USCIS has issued that carries long-term consequences. False claims to U.S. citizenship, even if made years ago, can result in a permanent inadmissibility bar. If at any point in your immigration history you made an incorrect statement about being a U.S. citizen, this is something to discuss with a qualified attorney. The agency has also placed new emphasis on expanded vetting procedures during interviews and background checks, including deeper review of public information, travel history, financial records, and prior immigration history. Applicants should be aware that the documentation and verification standards in 2026 are more rigorous than they were in prior years. Let's talk now about interviews, because this is something that is directly impacting thousands of applicants right now. Starting in early 2026, USCIS updated its policy manual to significantly restrict the circumstances under which green card interviews can be waived. The stated reason from USCIS is strengthening fraud detection and ensuring that benefits are granted only to those who are genuinely eligible. For marriage-based green card applicants, interview waiver rates have fallen dramatically in 2026. Approximately 6 to 9% of marriage-based applicants are receiving waivers, meaning more than 90% are being required to attend an in-person interview. If you are in a marriage-based case, you should assume you will be called for an interview and prepare accordingly. For employment-based I-485 applicants, about 72% still qualify for interview waivers. But that still means more than 1 in 4 employment-based applicants who previously would not have needed to attend an interview now must go in person. What has changed in these interviews? USCIS officers are now asking expanded questions about travel history, prior addresses, financial information, ties to foreign governments, and social media accounts. Officers are also separating spouses in marriage-based cases and questioning them individually before comparing answers. This is a known technique designed to identify inconsistencies in cases where the relationship may not be genuine. Here is the preparation advice that immigration attorneys consistently give. Review every document you submitted: your I-485, your I-130 if applicable, your I-864, all supporting evidence, before you walk in. Be consistent between what you said on paper and what you say in person. Be honest. If there's something you're unsure about, say so rather than guessing. USCIS officers are trained to detect inconsistency, and misrepresentation, even unintentional, can seriously complicate your case. After the interview, cases may be approved on the spot, placed in post-interview status for additional review, or result in a request for evidence. Post-interview holds are increasingly common in 2026 because of expanded vetting requirements. If your case is placed in this status, do not panic. It does not mean denial. It means additional review is in progress. Now let's talk about processing times, because the reality right now is that things are moving slowly, and people deserve an honest picture. As of April 2026, most green card cases are processing within a range of roughly 11 to 32 months, depending on category, field office, and individual case complexity. The I-485 adjustment of status application specifically averages about 8 to 14 months, but that range is wide, and outliers on both ends exist. The I-130 petition, the first step in most family-based green card processes, can take up to 35 months when filed by a permanent resident on behalf of a family member. Perm labor certifications, which employers must complete before filing an I-140 immigrant petition, are adding over 16 months to employment-based timelines at the Department of Labor level alone. That's before USCIS even touches the case. USCIS has publicly reported over 11 million pending cases as of early 2026. The agency has experienced staffing changes that have affected its capacity to adjudicate cases and conduct interviews at the pace previously maintained. Immigration attorneys have noted that this is slowing overall case movement. For applicants from countries subject to processing holds under the presidential proclamations, delays can be indefinite with no clear end date in sight. For H-4 EAD applicants, spouses of H-1B workers who need employment authorization, processing times are running 6 to 10 months as of April 2026. Premium processing is not available for this form type, meaning there's no way to accelerate the timeline beyond filing early and filing correctly. One more thing that's causing rejections and delays in 2026: outdated forms. USCIS has been returning applications at a higher rate for using old form additions or incorrect fee amounts. The premium processing fee increased to approximately $2,165 as of March 2026. If you submitted outdated fees or an old version of a form, your application may be returned entirely, and you'll have to start over, losing both time and money. Always verify you are using the current form edition from uscis.gov before submitting anything. Let's also briefly cover diversity visa applicants, because there is a hard deadline you need to know about. If you are a DV 2026 selectee, your visa entitlement expires on September 30th, 2026. That date does not move. It does not get extended. If you have not completed your visa process and been admitted to the United States by that date, your selection is gone. Permanently. No carryover, no exception. The Department of State has noted that immigrant visa numbers in DV and other categories have been advanced in part because issuance rates from certain countries have decreased under current presidential proclamations. This has created additional availability for applicants from other countries, but officials are also warning that if demand from those other countries increases, or if policy changes occur, retrogression could follow quickly. If you are a DV selectee, treat September 30th as a firm and immovable deadline and act with urgency. Let's finish with the most important practical guidance: what you should actually do right now. If you are in an employment-based category, go to USCIS.gov today and look at the May 2026 Final Action Dates chart for your specific category and country of birth. Compare your priority date against that chart. If your date is current, speak with an immigration attorney immediately about filing your I-485. If your date is not current, keep your documents organized and your medical exam current, and monitor the bulletin monthly. If you have a pending adjustment of status application that is not yet decided, monitor your case status on the USCIS website regularly. If your case has exceeded the posted processing time for your form type and service center, you are eligible to submit an outside normal processing time inquiry, also called an e-request, through the USCIS website. If you are in a marriage-based case, begin preparing for an in-person interview now. Review all your filings together with your spouse. Make sure your supporting documents, photos, financial records, shared lease or mortgage documents, joint accounts, are organized and current. If you obtained any immigration benefit in recent years, and there were any complications, inconsistencies, or unusual circumstances in your original case, it is worth a consultation with a qualified immigration attorney, not because you should panic, but because being informed is always better than being caught off guard. And regardless of what stage you're at, make sure every form you file is the current version from uscis.gov, uses the correct fee, has all required signatures, and is submitted to the correct address. Filing errors are triggering rejections at a higher rate in 2026, and a returned application can cost you weeks or months. The immigration landscape right now has real opportunities and real risks happening at the same time. The employment-based current window for most countries is a genuine opportunity that may not last long. But processing timelines are long, scrutiny is elevated, and the rules are shifting. Staying informed and working with qualified professionals is not optional right now. It's essential. If this video gave you something useful, share it with someone who needs it. Drop your questions in the comments below. We read them and cover them in future updates. We'll see you in the next one.